All right, we are live and recording. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Okay.
Good morning, Your Honors.
Good morning.
My name is Barry Backrack.
Well, let me call the case first. The first case on our list. The first case on our list this morning for argument is case number 2018 P 1530, the Commonwealth versus Gerard L. Moakwood.
Okay. Good morning, Your Honors. My name is Barry Backrack, and I represent David Cosmi in this matter. This is an appeal.
Just for the record clear, this is the Cosmi case.
Yeah, we didn't call the right case, Chief.
Oh,
Chief,
I'm sorry. I'm sorry.
It's the Cosmi. That Moakwood was removed.
19P 1732.
19P 1732.
32.
Commonwealth versus
Commonwealth versus
David
David Cosmi. Excuse me. I'm sorry.
Go ahead, Mr. Mack.
Okay, thank you, Your Honor. Good morning, Your Honors. My name is Barry Backrack, and I represent Mr. David Cosmi in this matter. This is an appeal from the trial court's denial of Mr. Cosmi's motion to suppress and a motion to dismiss. Mr. Cosmi submits that the trial court erred by failing to rule that his constitutional rights were violated when police ordered him to exit his vehicle, and then, as the trial court found, they conducted a search of him and his vehicle after he complied with all police orders and was handcuffed. I'd like to address initially the exit order. And for an exit order, the SJC in the Torres Pagan case made clear that in order to issue an exit order, the police must be warranted in the belief that the safety of others or officers is threatened. The police have a reasonable suspicion of criminal activity. In this case, it arises out of a phone tip by a known informant who said that there's a male shooting at a target at the Matthew Cass boat ramp, as the trial court found. The caller further said people are in the parking lot and he's there shooting. The police responded.
Hold on. Didn't the caller also say that he was standing near or in a red Jeep? Wasn't there some mention of the vehicle, sir?
Yes, Your Honor.
Well, that's important.
Yeah, the trial court also said that the shooting person has a red Jeep Cherokee. Okay. You're right, Your Honor. And when the police arrived, they formed a tactical formation and proceeded toward the parking lot. And in the parking lot, there were two cars, one on one side, the red Jeep, and there was another car on the other side, and they saw two people on the other side, so some officers split off there.
Why do you think they formed the tactical approach, or why do you think they engaged in a tactical approach?
Because the report was that they had heard shots fired. Someone was shooting at a target in the public area, and I think just out of concern and caution, they formed a tactical approach to make sure that they had the matter under control.
Okay.
And as they approach, the testimony was that they saw that the officers saw a male in the driver's seat of the red Jeep, which had been reported. As they got closer, the person in the red Jeep put his hands up, and he was ordered out of the vehicle at that point. And I first say that the exit order was unlawful. At that point, the police had no articulable specific facts that this fellow is sitting in the driver's seat of the red Jeep had committed a crime or was committing a crime. Furthermore, the second prong.
Okay. Go ahead.
The second prong as to whether the police reasonably believed on specific facts that there was a fear for public safety or their safety. At this point, the fellow has his arms up like this. He's envisioned. The police are approaching. The testimony was that the police did not know at the time of ordering him out of the vehicle if he was the person that allegedly had been shooting a rifle at a target. And that's the transcript on May 23rd at page 26. There had been no description of the male. The only description was that there was a male who had a red Jeep. But there was also...
So, counsel, let me just interrupt you for a moment.
Sure,
the known caller gave this information to the police and told the police that he was standing by or in the area and would meet them nearby should they need anything additionally from him. That was before they arrived. Is that right?
Correct, Your Honor.
All right. And when they arrived, the parking lot was fairly empty, except for the two people that you mentioned, and then this red Jeep that was off in a portion of the parking lot. Is that right?
Correct, Your Honor.
And they spoke to the two people before they approached the red Jeep. Is that correct? The other two people who were in the parking lot?
They went over to the, and they did have them get on the ground, handcuff them, and they did speak to them, but neither of those people identified Mr. Cosby as the shooter until he was already out of the vehicle and handcuffed.
Do we know what, if anything, they did say before he was out of the vehicle?
No.
Okay. All right. Go ahead.
And with respect to the other key factor here too is, number one, three officers testified at the hearing. Now, one of those officers spoke with Mr. Frazier, the informant, when they arrived at the scene. Officer Custuvio, I'm sorry, I have his name, testified that someone spoke to him, but he wasn't sure what he said. And so they didn't derive any additional information at the scene before they went down and conducted their the stop and the search of Mr. Cosmi. And I think that's key, the fact that none of them testified what Mr. Frazier said at the scene, because the fact that then they're left with the car only, which identified a man with a red Jeep, and also indicated that there were other people in the parking lot at that time. And no, we don't know what happened to the other people in the parking lot from the time that the call came to the time when the police arrived on the scene.
Well, other than the fact that somebody's in the parking lot shooting, they may have all left, but I mean, that's not really relevant to the analysis, is it?
Well, I think it is, Your Honor, because there's no description of who was doing the shooting. Other than
but there's a description that there's an armed man shooting in a parking lot in or at a red Jeep, or he has a red Jeep. They approach the only red Jeep in that parking lot with a man in it. Do they have to have more at that point? Your suggestion is they have to know a description of him and who it is and make inquiry of him before they can have him exit the Jeep?
I think they do, Your Honor, because I do believe the fact that there were other people in the parking lot is relevant, because we don't know if there was other people involved with him doing it, whether they...
Why would that be relevant?
What?
Why would it be relevant if there were that there were other people with him in terms of providing reason to inquire of him?
Well, we don't know if the other people might have been the ones who were shooting and he was a stander by. And own the red Jeep, and there's just no evidence.
So what would you have the police do, sir?
Well, I think the police at that point, when they're coming down the tactical formation, they see his arms up in the air.
I'm not sure that they saw that before he was ordered to do that, but leaving that aside for a moment, go ahead.
Okay, the police at that point should come down and conduct an inquiry, inquiry of the fellow, and not order him out of the Jeep, because one, they didn't corroborate the fact that they corroborated that there was a red Jeep and they corroborated a male, but they don't know whether that was the male. And there was other cases I cited in my brief where a description of the person is extremely important in order to determine.
But doesn't the fact that it's a known caller lend some veracity to the tip?
I agree the known caller lends veracity, but that's why I made the point. I believe I read the transcripts very carefully, and not one of the three officers who testified spoke with the known caller at the scene. So they didn't get any, so the officers who testified and gave the evidence, and as they approached, didn't offer any other information other than there was a male in or near a red Jeep.
Shooting.
He had been shooting at a target, yes.
And this was in the daytime hours across at a public parking lot at the beach across the street from a middle school, is that right?
It was at the noontime hours, and there was a middle school in the area. And there was also other business establishments in the area, but it was noontime. And they also, I think it's important, the number of officers outnumbered. This isn't a situation where an officer pulled someone over in the middle of the night and it's dark, and the officer is one-on-one, or the officer is outnumbered by the people in the vehicle. This is a situation where the officers, it's a daytime, they can see his arms up, and they see his arms up, and they can determine whether or not it's a safe situation. But if I have 3 minutes, Your Honor, if I could move, because even assuming he was allowed, the exit order was appropriate, I think that the trial court erred in connection with the pat frisk. The trial court actually ruled on, it's at the addendum of page 39, as a result of this encounter and operating on the information that they had accumulated by way of not only a phone call, but their own observations, the officers searched Mr. Cosmi and also searched the vehicle. There was no basis for a search at that point, as the officers admitted that they did not know if this was the person who was shooting, and that's at page 26 on May 23rd. And they didn't know, and he was not under arrest upon his exiting the vehicle at page 28 of that same transcript. And in order to conduct a pat frisk, you have to reasonably believe he's armed and dangerous. By this point, the fellow had his arms up. He was ordered out of the vehicle. He got out of the vehicle and complied with all their orders. He knelt down, laid on the ground. They handcuffed him. And at that point, they did the pat frisk after they had already handcuffed him. And at that point, I would say, Your Honors, that similar to the language in Torres Pagan, he was not, they had no reasonable belief that he was armed and dangerous. Certainly he wasn't dangerous at that point. They had him under control. They outnumbered him by a number of people. Putting aside the trial court's use of the word search, because I think we'd all agree that there's no probable cause for a search, and they shouldn't have searched the vehicle at that point. The fact is that I don't believe there was a constitutional basis for a pat frisk. because.
Let me ask you one other question. When they pat frisked him, they recovered some weapons from him, the double-edged sword or some double-edged knife. Is that correct?
Yes, Your Honor.
And that happened before they searched the vehicle.
It was a little unclear to me on the timing, whether it was somewhat simultaneous, but even if that's the case, Your Honor, even if that's the case, the only would get the right to search it if they found the knives, if the pat frisk was appropriate. And it's our position that the pat frisk was not appropriate because there was no reasonable belief that he was armed and dangerous at that point. I'll rest on my brief on the Second Amendment. If there's no other questions, I think I've addressed the key points I wanted on the exit order and pat frisk.
Okay, thank you.
Thank you, Your Honors.
The Commonwealth.
Thank you, Your Honor. Stephen Naylor on behalf of the Commonwealth, standing in for ADA Alicia Sanchez, who wrote the Commonwealth's brief in this case. Addressing the issue that counsel addressed in his argument, there was sufficient cause here for both the exit order and the pat frisk. This case is distinguishable from those cases the defense cites, such as Gomes, Lyons, and Brinkley, in that here, unlike in those cases, we have an identified 911 caller who identified himself at the time on the call and remained in the vicinity to be available to talk to the police. He described, and I significantly, unlike in Gomes and Brinkley, actual discharge of an apparent firearm, a rifle, rather than just someone carrying one. That would present to police a much different calculus in the terms of their own safety and the public safety risk generally, particularly given the description of other people being in the parking lot in the 911 call and the general geographical description where there's a supermarket, middle school, nursing home, and some residential houses nearby. And not just principle of safety, but just there's a statute that criminalizes discharging a firearm within 500 feet of a building. I don't know what the exact feet distance is here, but there is some indication that an enumerated crime could be being violated here. And that concern for the safety of the public and their own safety was evident in the officer's entire approach as a organized, tactical approach to the defendant's car.
Can we infer, I'm going to interrupt you for a second. Can we infer that when the police spoke to the other two people in the parking lot, that they didn't say anything about a shooting?
I don't think we can infer that. It just seems that the substance of that conversation is not before us, but they excluded them somehow from involvement in the shooting.
And they certainly didn't corroborate any shooting about the red Jeep that was in the parking lot while they were there.
That's not apparent on the record, I believe.
Right.
But nonetheless, based on this, and so we sort of don't know what those other two guys were doing in the parking lot, if they had showed up after. I do think it's significant that when the police arrived, the caller had described, there was a red Jeep Cherokee in the same parking lot close in time. This isn't a case where they stopped the vehicle in the vicinity, maybe as it was driving away and having to match a description. This was, as described, in this same location, as described, one male inside the car at the time. And the police are allowed to take certain measures, such as the exit order, when their concern for safety is justified, as it was here. And then the exit order would follow from that. Although it might be apparent that he would have a rifle on his person just visually. That itself is not certain, nor should the police, when their safety or the safety of the public is at risk, count on the defendant only having perhaps one kind of weapon. And so on, even under Torres Pagan, the pat frisk was would have been strictly limited to, patting down the outside of the clothes, would not have been allowed to go further unless some indication of an actual weapon on his person presented itself, which it did in this case, leading to the discovery of the double-edged knife and some other items. And then at that point, although it's not directly challenged in this appeal, apparently the search of the vehicle could continue where the rifle had not been located. And I believe Your Honor had referenced the sword type weapon. I think one of the officers described that as observable, almost in plain view, kind of sticking out from at least partially underneath the passenger seat of the vehicle. At least that's my recollection. So under all these circumstances, the Commonwealth suggests that the motion to suppress was properly denied in this case. If there are no other further questions on that issue or the second issue, which the defendant did not address in argument today, the Commonwealth would rest on its brief.
Seeing none, thank you both.
Thank you.
Thank you, Your Honors.
All right, we are live and recording.
The next case on our list for hearing is case number 2020 P160, the Commonwealth versus YEFFRY Delacruz.
Good morning, Your Honors. Kathleen Hill on behalf of Jeffrey Delacruz. May it please the court. This claim is grounded in two arguments. The first claim is a sleeping juror, and the second claim is a juror bias claim based on a couple of issues contained within juror number 12. And it's within the context of a motion to reconstruct the record. And from that motion to reconstruct the record, an appeal was taken. Appeal was taken with regard to the, with regards to specific wording of the two claims, a sleeping juror and the biased juror, which would be prospective juror number 12. In my first brief, when I filed my first brief, it was my understanding that the record was established and clear. And so therefore I had set forth two standards of review. And I would like to argue today, first and foremost, which I had presented in the alternative, that it is a structure error with regards to juror bias of juror number 12. And that being is so.
But don't we have to resolve the question of the record before we engage that issue in that way?
Yes and no, Your Honor. I did break it out into two separate claims. The second claim was just exclusively with regard to juror number 12 at that time on the basis of a certified record.
I understand that, but we have before us, you recognize, a request within our jurisdiction under Rule 8E.
Oh, yes, Your Honor, and that was.
So why don't we talk about that? Because it seems to me that if the record in fact is as your argument depends, is inaccurate, and the response was not yes as the first transcriptionist said, but no sir as the second transcriptionist said, then it's a very different argument, isn't it?
Yes, it is a different argument, and the argument taken on appeal with regards to the reconstruction of the record was that the substitute trial judge in this instance did not provide us a hearing so that the record could be corrected. Also, too, he didn't make findings of facts.
Well, I understand that, but I go back to my comments introducing the issue for purposes of this argument. We as a panel, as a court, have authority to step in where the trial judge declined to do so, correct?
Yes, you do.
And that issue is before us. So why don't we engage that question without regard to what the trial judge did or didn't do, and see if we can reach some determination of what's going on with the record.
Sure. Yes, Your Honor. Well, with regards to that, we have strongly objected to the second look of the reconstruction of the record, in which the Commonwealth is challenging after the brief was filed in this case, and after.
Wait, let me just stop you there. So you are suggesting that we ought not to consider it. We ought to consider the record closed because you had filed your brief.
No, not because the brief is filed. Because of the fact of the reconstruction, I think the Commonwealth has brought out the new argument is.
Why don't we do this? Let's proceed on the expectation that we as a panel are going to entertain the Commonwealth's motion to correct the record. And why don't you engage the merits of that motion?
Okay, with regards to that, I renew all the arguments that I raised in the trial court, in that arguments I raised in the appeals court, and arguments that I raised in the SJC, because.
So let me just, I want to just, before we, so I'm clear. Is it your position that the Commonwealth agreed that juror number 12 said yes, sir, said yes? Is that your position for starters?
Yes, Your Honor. Not only did the Commonwealth agree, I think when you just take a look at the context of reconstructing, the process that goes through, what we do is when we go to reconstruct the record, there were 3 drafts, and if you take a look at the actual reconstruction of the record in your appendix on page 76, I direct your attention. Well, that would be to the sleeping juror.
Right. So hold on. Look, let me just make sure I'm clear. You believe that the government at one point in determining what the record was, agreed that juror number 12 said yes in response to, would you be biased because he's using a Spanish interpreter? And isn't that a fundamental dispute? I took from the papers that the government never agreed to that.
Well, you know, Your Honor, what you can take a look at, that I have laid out in the context, the entire presentment of the voir dire of prospective juror number 12. Now, if you want to pull out yes, yes, and no, sir, I don't think that's realistic. You read it in the context of what the judge of the individual voir dire. We had 3 rounds of that. So therefore, you read it in the context. The Commonwealth reads it in the context. And then they have the opportunity.
Let me just stop you there on context, as if I read through the sequence of questions and answers and the progression of what took place resulting in juror number 12 being seated, it is extraordinarily difficult for me to imagine that the juror was asked, would you have bias, said yes, and then everybody proceeded as though nothing had happened and the juror was seated. So I don't think context helps you very much.
Okay.
I should advise you that we have listened to the audio of the sidebar, and while it is challenging to make out everything with complete clarity, we can hear for ourselves what was said.
Yes, and what is being hotly contested is there is no evidence that it is one and the same recording that we listened to when we reconstructed the record and that the original transcriber listened to. In this instance, the original transcriber has not given her.
But this is a question of correcting the record. And the Commonwealth is within its rights under Rule 8 to bring forward the audio of the proceeding from the trial court, which they have done from the FTR system. And we can listen to that on the Commonwealth's request to correct an error from whatever source made by the first transcriptionist.
And the objections to that were set forth 3 times, and that is, number 1, it's not the entire impanelment. And so when you take a look at just those questions, I say it's too small. You need to look at it in the context of the jury impanelment.
But you want to tackle the entire impanelment. I'm sorry.
Go ahead, Ken.
You want the entire impanelment wasn't at issue. What was at issue was juror number 12's response to a particular question in the course of the voir dire.
And it's not a particular question. It's actually 3 questions. And that's what I'd like to direct the court's attention to. There are 3 issues within prospective juror number 12. And that is when she's first asked, did you have any difficulties with the court in your prior experience? And she differed, saying that She believed she wasn't treated fairly. Well, if you go back, and this is de novo review, so if you read juror number 5, you'll see that juror number 5 was for cause, was not seated because that particular juror had an issue with being treated unfairly by that particular district court. And so but however, that one is out for cause because she's asked more questions. It's a sensitive voir dire. But when this juror comes, and Your Honors, there had already been 4 other jurors that had been stricken for bias, along comes this juror, and the judge moves on. And not only
doesn't that tell us something? Doesn't that 4 other jurors had already been stricken for bias, and yet there was no.
It's not even-handed. There wasn't the questions, the sensitive voir dire that you would expect to hear when something like that is said. And then the judge, in this instance, gets to the police bias, and 3 times she's saying, yes, I do have a bias. And that's where there's an unclear part, and that's never corrected. In addition to that, when you have those 3 lines of questioning, and juror number 12 is seated immediately, there's also, when you take a look at the preemptory strike, the trial counsel he's having to manage all these different issues of potential bias and keep track of them. And I have argued that I believe, with regards to the analysis, that he was inattentive. It's not necessarily that it was intentional. And then I would like to raise with regards to—
You had a peremptory left at the time that the juror was impaneled, right?
I'm sorry, Your Honor.
He had a peremptory left at the time the jury was seated.
Yeah, yes, he did.
Okay, and so, but you are not bringing this. You didn't bring a new trial motion claiming ineffective assistance of counsel. You are asserting that the trial counsel missed a rather significant factor without having established a foundation for that.
Well, I think it's there, and it's in my response to the brief as well. And I'd like to put it together in the oral argument, and that is Commonwealth versus Grady, I think, shed some light on this, which is where a pre-trial motion in limine, no objection is needed. This came about in 2016. So in this case, trial counsel had filed a pre-trial motion. And so that particular question was going to be asked and agreed to. So if you follow the line of reasoning of the cases over the last few years with regards to this issue, then if it's applied to evidence in a trial setting, why wouldn't it be applied on a constitutional error that can rise to the level of a structural error? What gives us direction? I think Commonwealth versus LaChance, and then Commonwealth versus Chambers as well too, the dissents in those where it's very difficult to show prejudice in a structural error, in an error.
All of those presume that the record is as you wish us to see it.
Well, yes, it is there in effect. And then, so if you take a look at, are you going to correct at this stage, you would have to litigate. My objections
That's what we're doing.
Honor, I'm sorry.
That's what we're doing. I mean, the Commonwealth is within our authority under Rule 8E to correct the record.
Sure. So you take a look at why the judge opposed it. And I presented the argument there that there must be some phenomenon, how you can have in one setting of the transcript, you hear this, there must be some technical explanation, which would involve an expert to be able to take a look at the record, to be able to take a look at the recording. Without doing this, there is nothing in which you can say that the first isn't true and accurate, unless you have somebody take a look at the equipment, which would require us to actually litigate in the trial court. Then you would also too, with regards to that, my arguments are the Commonwealth has waived its right. They had the opportunity and they did. They did correct the record at that time. So there was no objection at the time that I filed all the motions and the supplemental motion to correct the record. The other objections is with the authentication. Normally what's done when there's a dispute, there is the original recording that needs to be given from the first transcriber. When you compare side by side, which this is de novo review, when you take a look at the transcript of the first with the second, you'll notice precisely at the time in which there's no sir versus yes, sir, a 2-second delay. Why is there a 2-second delay in this recording from two different transcribers? So there are those issues that need to be flushed out and addressed, and the form of that in which you would do it would be in a trial court. And the trial court's decision would be final. And in this instance, where the judge specifically said that
wait, you said the trial court's decision would be final?
On deciding not to correct the record. A judgment.
Where do you look for authority for that proposition?
I would refer the court to Belch versus Paul Clark. The district court may decline to correct the record if it has no recollection with regards to the matters.
Yes, but that does not deprive the appeals court of the authority that we hold under Rule 8E to entertain a motion to correct.
You are entertaining the motion to correct, yes. Yes, and it is de novo review. So you would take into consideration the entire transcript. So when you lay the two transcripts side by side, you will see even differences in the last three of the second transcript versus the transcript of the entire impanelment. So if this is going to hinge on the fact that you correct that, oh, I see my time has expired.
Finish that sentence.
I would urge this court to look to the other components of juror number 12, in which it wasn't ascertained whether there was juror bias because there were not the questions.
We will take that into account. Thank you. Okay, for the Commonwealth.
Can I?
Okay.
Go ahead. I'm sorry. Let me let you introduce yourself.
I'm Catherine Stemmel on behalf of the Commonwealth. Good morning.
Good morning.
Justice Desmond?
Yeah, I just want to ask one question following up on what your sister kind of left off at. If the parties agree to portions of the record by way of stipulation, which is what happened here, right? You guys went back and you settled portions of the record that were inaudible by agreement.
Correct.
And if that there remained some other portions that you couldn't resolve, and you're looking to have the court resolve those portions, does the court then have to go back and review the entire transcript, even the portions that you've already resolved by stipulation?
The Commonwealth is not asking the court to resolve the other inaudible portions of the record. I mean, I do think we have two different things going on under Rule 8 here. We have the defendant's reconstruction, which was pursued cooperatively by all parties, and they came to an agreement as to certain inaudibles, and the judge validated those, and other inaudibles were just left because no one had any suggestion of what they might be. And then later, the Commonwealth brought a motion to correct the record as to a portion of the record that was not inaudible, that was not part of that reconstruction because it was not inaudible, even though it was in the same area of the transcript. And that is a very finite, issue. I think the defense is operating under a notion of record reconstruction, which is not one that has been accepted by this court, that's appropriate under the rule, that is some kind of global verification and validation of every word in the transcript that then can't be touched. And it's a much narrower construct than that. There were specific inaudible portions that were reconstructed. There are other inaudible portions that were not. And then the Commonwealth has moved to correct something that was actually transcribed the first time. So I'm certainly not calling on the court to go back and correct every portion of the record. I think that the issues as presented to the court are on the defense side, is the record sufficiently reconstructed on the defense reconstruction for purposes of review, which the Commonwealth strongly argues that it is. And then the second part, the Commonwealth's motion to correct the record, which goes to a different issue by the defendant with regard to claimed bias as to juror number 12. And I would just reiterate that the Commonwealth at no point agreed to the correctness of any audible portions of the record. It's very clear, and I pointed out passages in my brief. It's clear in the affidavits of the two defense trial counsel in support of the motion to reconstruct the record. It's clear in the motion itself, which the defense drafted and all of the parties signed, that the scope of that motion was what we would understand it to be, was to to reconstruct portions of the record that were inaudible. And
Your
there
position then is that it does not automatically accept all the remaining audible portions.
Correct. That's the Commonwealth's position. And I think it's clearly supported by all the documents in this case.
Just as an aside, this case was tried in Salem, right? No?
Lynn.
No, Lynn. Thank you. Yes, Lynn.
Has there been any effort to go back to the trial court in that courtroom because on a long-term basis, when we have this many portions of the transcript that are challenging based on an electronic recording, it would be helpful for counsel who discover that to go back to the officials in charge of that facility and see what we can do by way of microphone placement and otherwise to improve the resulting product.
That's certainly true, Your Honor. And I can't say it was done in response to this particular case, but it has been an ongoing discussion with our office and the various courts. Particularly sidebars have been a real problem since the FTR system began. And
I'll let you continue with your argument on the other issues, but I would ask you to work both with the clerk's office in those courtrooms where you have difficulty, and also with the Office of Transcription Services. And I say this to defense counsel as well. We're never going to make improvements where we have issues with the electronic recording, and we are going to be dependent on electronic recording over and over again. The technology is good. We have 8 separate channels, and we should be able to get a good record. But we need, when we encounter difficulties, we need to figure out the source of those difficulties and then take steps to address them.
Certainly, we'll try.
We know that the trial judge in this case, Judge Conlon, retired, and the substitute judge was actually the first justice of Lynn. Isn't that right, Judge Nestor?
That's correct. Yes, and we will address it anew. Thank you, Your Honor. As for, I will move on from our motion to correct the record, just briefly touch on the other issues. The defendant's reconstruction, as I've already discussed a little bit, was, I think, appropriately handled by Judge Nestor. In this case, he reached out to Judge Conlon. Judge Conlon didn't have any notes or memories. He adopted everything that was agreed to, and there was basically nothing left on the table. That is, everything that was proposed by the defense as to inaudible portions was agreed to by the trial prosecutor and was submitted to the judge as is. So there was basically nothing else that could be done in terms of what the parties thought they could hear or thought that they remembered. And the defendant has not established that there are any articulable claims that he cannot raise due to the portions that are still inaudible. In this area is where, I'm sorry?
Isn't that a little bit too?
It can be, but I think we've certainly seen cases where trial counsel might know that they brought a certain objection or might think they brought a certain objection. And then in circumstances like that, when there's some specific memory about something that is not in the transcript, then in those cases, I think the court has held, and I think McWhinney was one of those cases.
Well, but even in the absence of specific recollection of something that would give rise to an issue for appeal, there could be circumstances where the transcript is so inscrutable that you're unable to determine what happened at all. And in that instance, there would be a concern of whether the defendant is being deprived of an opportunity to raise a valid challenge because of the impossibility of getting a record.
That's certainly true. And I think it comes into play much more when you have trial testimony missing, sometimes opening and closing arguments, especially if there's some information that there might be something in there that is troubling, that might form a basis for appeal. In this case, the defendant just has not been able to identify anything that is pertinent. I mean, I think the main thing that the defendant relied upon was Juror 12's inaudible response to another question, to the police testimony question. But from the context of that response, just like the context of the response to the interpreter question, it's clear that there was no follow-up, there was no request for follow-up, there was no challenge, there was no reason to believe that that response would be helpful to the defendant, that it would show any bias at all. And I think that's the most clearly articulated claim by the defendant. The defendant also raises a claim about a sleeping juror, which does not really have to do with the record reconstruction. We actually were able to reconstruct portions of the judge's colloquy with the juror, which were helpful in terms of evaluating the issue. And I think also demonstrate that there was no error by the judge in handling that issue. Just not objected to.
Juror cases in the last several years. And they are the most challenging when the judge doesn't conduct a voir dire. Here we had not one but two voir dires with the same juror, and defense counsel threatening to or objecting to the possibility that the judge is going to discharge the sleeping juror. The sleeping juror ultimately was made the foreperson. I don't know whether that was done at random. From the context, it appears that was done based on the perception of all involved that that juror was the most engaged of all of the jurors.
Well, I'm sorry, what were you going to say?
No, I was just going to agree.
Was she also in seat 1?
She was in seat 1, yes.
Okay.
Yes. So it's possible. It's not. I agree, though. It's not clear from the transcript how the juror number 1 was selected as the foreperson. And to just add what you pointed out, Justice Green, all of those points, I would just add that in any event, after both incidents, the attorney who was examining the witness went back and backtracked a bit and picked up and re-inquired of the witness, where they were when the issue was first raised. So it was covered on really every possible angle in that regard.
Your sister would respond that in the course of inquiring as to what information juror number 1 may have missed when she was arguably asleep, that the prosecutor and the defense counsel had 2 different memories as to what her response was. And I believe she relies on that for the support that there may have been some structural error, or that juror was not suitable to continue on in the trial.
That's true. The defense makes that argument, and I would just note, as I think I noted in my brief, that that's where the record reconstruction is helpful, because one of the reconstructed portions of the record, which I don't think the defense mentions in their brief in this issue, had to do with the response as to what the witness was talking about. And it happens that the prosecutor was correct, and the judge may not have made any finding on the record, but the juror's response is on the record, on the reconstructed record. So I don't think there can be an issue there. And the juror was right about when the juror said what the witness was talking about, the juror was right. But in any event, even assuming error at any of those points, it was defense counsel who was examining the witness at that point. It was a defense witness. The defense counsel went back, not all the way to the beginning like the prosecutor did earlier, but went back and reiterated and backtracked a little bit. So all that testimony was in front of the juror regardless. If the court has no further questions, I would be happy to rely on my brief.
Seeing none, thank you both.
All right, we are live and recording.
The next case on our list is case number 2020 P75, the Commonwealth versus Byron Solis. You may begin.
Thank you so much, Your Honor, and may it please the court. Good morning, Chief Justice Green, Justice Desmond, Justice Lemire. I'd like to start, if I could, Your Honors, by quoting Justice Louis Brandeis in the matter of Ni Feng Ho versus White. That's almost 100 years ago when Justice Brandeis recognized that to deport someone is to deprive them of all that makes life worth living. And I think it's important to start here, framing the issue and reflecting upon the seriousness and the gravity of this. It's probably one of the most significant issues that can be addressed in a trial court and now in the appeals court. And in this case, the outcome of the case, which involves my client allegedly throwing beer bottles 20 years ago, which he may or may not have done, is going to determine whether or not my client is banished from this country, whether or not his 2 children will be left without a father, and whether his wife will be left to raise the children without him. The question will determine whether or not this man will be deprived of his right to support his siblings, to support his mother, and it may determine whether or not the man will have the right to live at all, given the fact that he will be deported to Guatemala, which is a country that is overrun by murderous gangs, a country in which he watched his own father, honorable panelists, murdered when he was just 12 years old.
Mr. Urquhart, this is your second motion for new trial seeking to withdraw the guilty plea that raises the immigration consequences about which you have expressed concern. The principal new argument that you make in support of the claim of error on appeal is that a McCarthy motion should have been brought and would have been successful.
In part, Your Honor, there's also, and I'm aided, Your Honor, by the fact that we were able to sort of, in an unlikely historical set of facts, obtain the police report in this case, which illuminated that argument as well.
I understand the police report. We'll get into that, and I understand that you also have a separate, subtly different argument about the precise nature of the immigration advice that your client got from plea counsel, and we will talk about that. But as I read your brief, the main argument that you're presenting is the motion to dismiss, rather.
I don't agree, Your Honor. I think that we clarify that the defendant's court-appointed attorney provided ineffective assistance as a matter of law, an issue that the appeals court didn't arrive at, but an issue that I think is beyond serious dispute. What remains in terms of beyond that point, then on the issue of prejudice, which I think will cause this panel to reverse Judge Hogan's ruling, are the manners in which we were able to demonstrate prejudice, not just with respect to the motion to dismiss the McCarthy motion aspect of this case, but also because of the motion to suppress that was left on the table. But really, and most importantly,
well, it wasn't left on the table. It was never brought, and we really don't have much of a record to be able to ascertain whether there would have been a valid basis for it.
Sure, that's correct, Your Honor, and it's an unfortunate reality of the situation, and I think it's something that the Commonwealth inferentially blames the defendant for. But I would simply point out on that issue that this is not a case where the defendant sat on his heels and waited until everything went away before filing this request for relief. He didn't know.
But regardless of where the causation may lie, the fact remains, does it not, that for you to prevail on the theory supported by the motion to suppress, you have to point to something in the record that suggests that the motion would have been successful.
Yes, Judge. So what I point to on the record is the police report that was written by the patrol officer, and in reality, we all know here that is the report, and there is no other report in this case. The officer states that they, quote, arrived on scene and we entered the first floor apartment. So Right there, there's evidence that there was no consent that was provided. But when
there's simply no evidence of consent is not evidence of no consent.
Yes, I understand that the burden is kind of twisting around here because of the procedural posture that we're at. But I think that if you look at Commonwealth versus Harmon, which is cited in my brief, that case points out that the presence of several uniformed officers or the impairment of the defendant's understanding by reason of drinking.
Look, what you're suggesting is that plea counsel was ineffective for failing to move forward with a motion to suppress. You don't have anything from plea counsel that identifies to fill in any of the gaps that you're asking us to assume in your favor.
Correct, Your Honor. All I have is the police report and the argument that I make regarding the inferences that can be drawn therefrom, and I won't dwell on the issue because I can see that at least one member of the court is not on my side on that point.
Again, I think inferences are one thing, but assumptions based on missing information as to your burden is another, and that's why I think I moved so quickly to your McCarthy motion. As I take it, your argument hinges principally on the failure of the reporting witness, the building owner, to identify the defendant by name as the person who was throwing the bottles, even though the defendant was the person who happened to be in the apartment from which the bottles were thrown when the police arrived.
He was one of two people who was in the apartment when police arrived.
The witness reported that there were more than one person throwing beer bottles, right?
Tenants. He said the tenants in the first floor apartment, Your Honor.
Okay.
So the
statement of the McCarthy motion is what?
I'm sorry. Yes, it's probable cause, Your Honor, but it's probable cause as to each and every element of the offense charged. And let me say this on the McCarthy motion. It's not just that the tenant that the witness doesn't identify my client by name. There's no evidence of this basis of knowledge in the police report at all. He simply states that the people in the first floor apartment are throwing beer bottles out the window. That's all he states. He doesn't say that he saw it. He doesn't say that my client was one of them. And he absolutely could have said that. And had he said that, that would have been in the report.
He's the landlord, right?
He was a landlord.
He's the landlord, and he says the renters are throwing bottles.
Says the residents of renters
are throwing bottles.
That's correct, Your Honor. So who's the renter here?
I assume the landlord knows.
Right. No, one could assume, but I don't know that you can make the inference that he saw that happen or that the defendant was one of the renters. I mean, people. I can come over your house. That doesn't mean I'm a renter, Your Honor. And I'd like to.
Of that, whether it happened, the police, upon their arrival, had their own percipient observations to corroborate what they had heard from the reporting witness, right?
That's correct. They found two people in the apartment.
Let's accept for now that the credibility and the basis of knowledge of the reporting witness is established by the corroborating observations upon arrival.
Okay.
And then he says that the tenants of the first floor apartment are throwing bottles. Well, they go to the unit and they find that there are two people there, and it's not. It doesn't exclude all other possibilities, but it's at least a rational inference that these are the people that were throwing the bottles. And if on a probable cause standard, I don't know. It's awfully hard to say that doesn't establish that they were the people who were responsible.
Let me make this as easy as possible. Please, Justice Desmond.
Well, they also saw the Formosa bottles, which is not Budweiser, not the most popular beer. And they saw Formosa bottles in the apartment, and they found broken Formosa bottles by the broken windshield of the car that was below.
Right, a real trail of breadcrumbs they found there for sure, Your Honor. And what I'll say on that point is, let's move past the mere presence issue, because there's a lot more problems with this police report. There's no evidence that whomever threw the bottles and did so willfully with the intention of hitting the car. So the bottles get thrown first, and it appears that they hit the car, But Officer Pangiotakis, when he goes into the apartment, has to go outside to see that the car was hit. You can't see the car from inside the apartment, and that's
Does it only have to be willful?
It absolutely has to be willful, and it has to be malicious. And I think that's
willful or wanton.
No, excellent question, Your Honor. And if anybody recalls Arthur Sherman of the district court, when I was an intern with the DA's office in Middlesex, he almost made me cry in court, questioning me about the distinction between willful and malicious destruction of property, and those are two separate crimes. So the wanton destruction is one crime, and that's not charged here, and it's not a lesser included. Malicious destruction is the charge that they chose here. This is the charge, please, Your Honor.
I'm sorry, did you finish your answer to Judge Lemire's question?
I think that I did try to answer Justice Lemire's question.
Wasn't there some evidence of animus between one of the renters and the owner of the vehicle whose car window got smashed?
That comes from the defendant's affidavit, Your Honor, and that was not part of the pleadings that would be relevant to the McCarthy/DiBenedetto motion in this case. So in reality, what Byron Solis recalls now is that Abraham Popjoy, the other fellow that was in the apartment, had an issue with the tenant whose window was destroyed. Obviously, we can't consider that in a McCarthy/DiBenedetto analysis here. But yes, Abraham Popjoy was the guy with the axe to grind and the bottles to throw, and Byron had to keep quiet about it because Abraham Popjoy had bragged about murdering his stepdad with a machete in the past, and so. But getting to the issue of
Mr. Erkan.
Yes, please.
As I understand your brief, you're asking us to find that the judge abused her discretion and that there was clear error of law and that your motion should have been allowed and to enter an allowance of your motion.
Yes.
You throw in or in the alternative to remand. You didn't argue anywhere that there was an abuse of discretion and not giving any evidentiary hearing.
You know, that's correct, Judge. And on reflection, in reviewing my brief in preparation for oral argument, there really isn't an important factual issue that needs to be resolved here. I think that this really is a question of law. I mean, certainly the court, on remand could consider the defendant's testimony as to what his trial defense was, what occurred with respect to certain other aspects of the case.
Are you asking to remand? And if so, are you suggesting there was an abuse of discretion in denying further hearing?
I think that there was I think that really the principal issue here is that it was a significant error of law for the judge to conclude that there was no ineffective assistance of counsel and that the defendant was not prejudiced by this, but because of this plea that he took to throwing beer bottles 20 years ago. The other issue, if I could, on the issue of the motion to dismiss as briefly as possible, is the malice element. I mean, that has to be there. It has to be there, and there's just no element of malice, hostility, motivations of revenge. That had to have been alleged.
Trial.
I'm sorry?
Why isn't on this record? It's at least plausible that through the full presentation of trial evidence that they could make that up, but we don't need to have it established again. This just has to be probable cause, and on this record, at least, it is at least possible, if not probable, that they intended to cause the damage that they caused. In fact,
I couldn't disagree more, Your Honor. Ilya I beg your pardon?
We don't have to agree.
Yes, thank you so much, Judge. But Ilya I and Umberto established clearly that the Commonwealth has to establish each and every element of the offense in the police report, the complaint application, and that's not established by speculation or inference. Speculation has to be established by facts, and it's not established by facts. But then, getting really to the heart of this, if we assume, as I think we must, that there was ineffective assistance of counsel here, the question of prejudice in the special circumstances analysis is just so clear. This man sacrificed everything to come to this country. He said goodbye to his family. He had nothing remaining for him or no life for him available in Guatemala. I'm out of time. He's out of time.
I think we have it. Thank you.
Thank you so much, Your Honors. Thank you so much. Appreciate it.
For the Commonwealth.
May it please the court, Emily Mello on behalf of the Commonwealth. I would ask the court to affirm the denial of the defendant's second motion for new trial, brought again, making essentially the same arguments and adding in, I think, 3, which would be the motion to dismiss, the motion to suppress, and adding an argument with respect to special circumstances. First, I would say that those arguments are waived as they were not brought in the first motion for new trial. And if this court is inclined to consider them, that the lower court did not abuse its discretion in failing to accept those claims and denying the motion for a second time. As to the special circumstances, there's a lot in his affidavit about what he's done for his family over the past 20 years and what he's done for his family in Guatemala over the past 20 years. But there is nothing to suggest that at the time of his plea that there were special circumstances or that he was doing anything in particular at the time of the plea that was assisting any of his family back in Guatemala. At the time, he had been in the United States for 2 years. He had a girlfriend, and that just simply doesn't amount to special circumstances. And that's not to say that anything he's done over the past 20 years is not good or whatnot. It's just that at that time, he did not have the special circumstances that are requisite for the claim. As to the motion to suppress, there simply is no evidence at this time to evaluate such a claim. We don't know how the police entered the apartment. We don't know the circumstances attendant to any of that. And that's simply a factor of the passage of time, and that must be resolved in favor of the Commonwealth.
Well, it's not just a factor of the passage of time, it's a factor of the absence of a record. I mean, you could go back despite the passage of time and obtain evidence to support the theory, but we don't have that.
Yes, Your Honor, exactly. Thank you. As to the motion to dismiss, I'd say that the police report does establish the elements for malicious destruction of property over 250. Obviously, I think the most controversial issue, or the issue with the most teeth here, is that willful and malicious element. But I would say to the court that if you look at the cases, if you look at Bell, if you look at Riley, I just want to read a quote from Riley. It says, just as the petite jury may infer a person's knowledge and intent from the facts and circumstances presented, a grand jury may conclude that there is probable cause by inferring a person's knowledge and intent from all the facts and circumstances presented. That the inference may seem less than compelling does not render the evidence establishing probable cause insufficient. And I think that that really speaks to the issue that comes up in a lot of police reports or comes up in a lot of grand jury presentments, is that issue of intent is often circumstantial and is really something explored with more particularity at trial. And I think that under these circumstances and with this police report, that the charges there was probable cause for that charge, excuse me. And if there are any questions from the court, and if there are no questions from the court, I would rest on my brief.
Seeing no questions, thank you both. The case is submitted. We are going to take a brief recess. We will resume at a little bit before 11 o'clock.
Personal care attendants from their coverage, meaning I am entitled to be paid the minimum wage and time and 1/2 for hours worked over 40 in a work week. Number 3, the statute creating the Mass Health Program does not exempt me from the wage and overtime laws of Massachusetts. Number 4, The regulations under which this program operates does not say anywhere that personal care attendants do not have to be paid according to the wage and overtime laws of Massachusetts. And if they did, they would not be lawful because only the legislature can change, modify, or overrule existing state statutes. Fifth, by only paying me for 3 hours of work when I'm covering 12 hours, my rate of pay was $3. Number 6, neither I nor Mass Health knows who made the rule that I would only be paid for 3 hours of work for working a 12-hour shift. There is nothing in the record to indicate whether that came from an employee from BCIL, Tempest, or Mass Health, but someone imposed it on me. Number 7, quite aside from all of the above facts, Mass Health regulations say that the patient I am serving is the employer. This is an oxymoron, legal fiction, and impossibility, because if he were the employer responsible for paying me, he would not qualify to be on this program, and I and the other personal care attendants are working under.
Wait, if I can just pause for a moment there, I think there's a difference between being the employer and being the source of the funds with which you are paid. And as I understand the way that this system is designed to work, the insurance, it provides a source of funds, and the program provides a source of funds that will provide reimbursement to the patient, much as health insurance pays for the cost of medical care for a patient who seeks medical care. But the person contracting for those services is the patient in the first instance, subject to reimbursement by a third-party payer.
No. The patient is listed as the employer. And yeah. I went through this. The consumer is listed as the employer. And I went over this already. And he's not the one that's responsible for paying us. Tempest issues the check, and Mass Health is like the bank account.
Let's talk a little bit about Gallagher, because that, I think, lies at this, that case dealt with precisely this question, did it not?
Yes.
Okay. And in Gallagher, it went through the distinction between who is responsible for making payment under the Mass Health program, and also the question of what happens if there are monies that are required to be paid above and beyond what Mass Health will reimburse. Right?
Right. I think the term we're trying to refer back to is surrogate.
Well, I guess my question to you is this. I know that in your brief, you suggested Gallagher was wrongly decided and should be overturned.
Correct.
Do you agree then that if Gallagher is not overturned, that it controls the issue of this case?
I don't think it should, no.
Well, I know that you think that Gallagher ought not to apply to this case because you think it should be overturned. But if it is not overturned, do you have an argument that this case stands differently from Gallagher, so that the principles developed in Gallagher do not apply to these circumstances?
There's a distinction here with there being no surrogate.
And how does that change the applicability of the legal analysis in Gallagher?
One moment. Could go to a surrogate in Gallagher, but not in this situation.
I know, but I understand that, but I'm not sure I understand why the presence or absence of a surrogate changes the role of the financial intermediaries in the overall employer-employee relationship.
One moment. I'll read point number 8. Both of my consumer's parents are deceased. Under the terms of his mother's will, he was allowed to remain in his parents' home for several months, and then he had to move and the home was sold. The entire proceeds of the sale were divided amongst his siblings. He could not accept any share because he would then not have qualified for the Mass Health program he is participating in. To my knowledge, the Commonwealth did not intervene in the probate of his mother's estate to recoup any financial responsibility she might have had if she were a signatory to the Mass Health program at issue here. The condo where he is living now was paid for by a family friend.
So
how does that bear on the status of the financial intermediaries?
I'm sorry, we didn't hear you.
I said, how does that bear on the status of the financial intermediaries?
Gallagher there was, here there is not.
In Gallagher there was, and here there is not.
What is the role of the surrogate in Gallagher that is missing here?
We could go to the surrogate for the funds.
Who's talking?
They could go to the surrogate for funds.
I take it that you have someone assisting you in presenting your argument?
Yes.
Off
Yes.
screen? Yes.
Yes.
And that is the attorney who represented you below?
Yes.
So is it your position that because you receive a check from one entity, that entity, as a matter of law, is your employer? Is that what you're saying?
Somebody is.
Somebody is, yes.
I know somebody is. I
They're
mean,
paying.
I know that the member interviewed you. Is that correct?
I'm sorry, I didn't hear you.
I say member, you may refer to him as the patient. That person interviewed you.
Yes.
Is that right? That person hired you, selected you to be his PCA?
Yes, that person.
Hold on. That person selected you to be the PCA? That person reviews your timesheets
Yes.
and signs off on the timesheets. So what difference does it make who pays you? If that person's uncle was writing the checks, that wouldn't make him the employer, would it?
I'm not sure on that. I'm not sure.
Well, I guess there are two specific portions of the Code of Massachusetts regulations that regulate this area that we talked about in the Gallagher case. In one, this is sections 422.411A1F and 422.420A6. That spells out the fact that the consumers have the right to hire and fire PCAs, to set their work schedules, to train them and to supervise them. And then another regulation provides that fiscal intermediaries are not responsible for paying PCAs for time worked in excess of what has been authorized by Mass Health. And the regulation does so with language that suggests that it's the consumer that would be responsible for payment of wages for that time. And that's CMR 422.416E4E. But we talked about both of those aspects in the Gallagher decision.
Okay. I feel as though Gallagher is wrong.
Well, Gallagher was based on the regulations.
I don't agree with the regulations.
Well, and I understand that.
Can I ask you, what would happen? You're paid, what, 3 hours and you put in 12?
Yes.
What would happen if are you allowed to leave after the 3?
No, because my consumer is on a ventilator for breathing. He needs 24/7 care.
Go ahead.
He can't, if there's an emergency, he can't advocate for himself. He can't walk, he can't talk. He has a tracheotomy, which is hooked to the ventilator for breathing.
But BCIL has determined that apparently it's not required that somebody be there for those 12 hours.
No, BCIL, Boston Center for Independent Living, knows that someone does have to be there for the 12 hours, that the regulations are inconsistent with the wage laws is what the problem is.
Well, I'm not sure.
Wasn't it BCIL's determination that only 3 hours are required at the evening?
I'm not sure who's responsible for setting forth allocating the hours.
Have you ever appealed it to BCIL and
Yes, and that's why we're here in the court system.
Well, but that goes not to the no one other than the consumer or your sense of what the consumer's needs are is compelling you to be there. The issue is what has the payer authorized as the level of care for which they will provide reimbursement. That's the dispute, right?
Correct.
So the member, the one who actually applied to be in the program, had to be evaluated to even be in the program.
Correct.
He's the one who would challenge the authority to only pay 3 hours. He says, my need is more than 3 hours. And so he was the one who would challenge the program and say, I need you to authorize 12 hours because my PCA has to stay overnight. But I don't know that you can take it upon yourself to just stay overnight and say they have to pay you. If you left after 3 hours, what would happen? Other than he would be unattended, and that would certainly be, not the right thing. But beyond that, there's nothing that makes you have to stay, correct?
Correct, but I would never do that. That's dangerous.
I understand.
Right. We don't know who decided on 3 hours. The BCIL knows that I am there for 12 hours. And wage and hour laws in Massachusetts state you're supposed to be paid for the time that you're there. That's the law, and that's why I've proceeded in this manner, and it's in court. Can I finish my argument?
Yes, you have about 1 minute and 45 seconds left.
Okay. Point 9, the patient needs 24/7 care to survive. As I have detailed in my affidavit, BCIL, Tempest, and Mass Health do not dispute this. Working the night shift, I have accompanied the patient to the hospital on a number of occasions for care. No one can sleep well during the day or night as we have to be attuned to the patient's frequent need for oxygen and his other needs. My last point, number 10, I rely on the legal arguments presented in my brief for reasons someone should be responsible for paying me according to the wage and overtime laws of the Commonwealth of Massachusetts. Thank you.
Thank you very much.
I understand we're almost out of time.
Yes, yes. Thank you very much.
Thank you.
How will the appellees proceed? Mr. Heineman, are you going first?
I am, Your Honor. Good morning, Your Honor. May it please the court. I represent Tempest Unlimited and Boston Center for Independent Living.
Why don't we start with the question that lies at the center of this case? What are we to do? What is Ms. Jackson to do in a situation where the patient requires much more care than is authorized for reimbursement?
There is a procedure for that, as the trial court below pointed out, that there's this evaluation that is done by BCIL and recommendations are made to Mass Health with regard to the number of hours. And then there's a certain number of hours that are approved. That's then called a prior authorization. If the member or the consumer or their surrogate doesn't believe that's enough, there's a process where they can ask for reevaluation and all of that. That's the proper procedure here that needs to happen.
Do you know if this member has a surrogate?
I don't know. They must, because as Ms. Jackson said, the person doesn't speak. So they must have a surrogate, but I don't know, and it's not in the record who the surrogate is.
And would that be something that the fiscal intermediary would be able to advocate on behalf of the member?
No, the fiscal intermediary purely handles payroll. That's Tempest. They purely handle the timesheets come in. We check whether there is a prior authorization on file. If there is, we pay it. If there's not, there's not. It would be BCIL, if anyone, that would have the ability to reevaluate if requested and make a recommendation to Mass Health with regard to how many hours the person needs a PCA for. But that process was followed. Mass Health made the ultimate and it's Mass Health that makes the ultimate determination with regard to the hours. BCIL does the evaluation and submits it to Mass Health. Mass Health made the determination of 3 hours here, according to the record. And there are processes to appeal that. That hasn't happened, apparently, or if it has, they were denied. But it does not, as your honors have pointed out, make either BCL or Tempest the employer. And I'd suggest that Gallagher's controlling in all regards. I'm happy to go through the argument, but it sounds like everybody knows that. So I'll rest on my papers unless there's other questions.
Seeing none, thank you. We'll hear from the EOHHS.
Thank you. Members of the panel, may it please the court. My name is Denise Tai, representing the Executive Office of Health and Human Services. And the issue before the court is who is Ms. Jackson's employer? And at least with respect to EOHHS, the statute is very clear that it is not EOHHS or a Commonwealth entity. And based on this statutory language, the court below correctly dismissed these Chapter 151 claims against us. And there are 3 reasons why that I'll cover very briefly that the court should affirm that dismissal. First, again, the statute is clear that a personal care attendant is not a public or state employee for purposes of these Chapter 151 claims. And the courts are bound by this clear and unambiguous language. Second, even moving beyond the statute, we get to the regulations and to Gallagher, which clearly identify who that employer is, which is the member who retains the right and has the responsibility to employ, hire, train, supervise, fire, and so on, a PCA. Just to provide some context, this PCA program is one intended to provide those who have chronic or permanent disabilities to remain in their own communities and in their own homes, rather than, for example, having to reside in a facility where they would receive care. And so as part of that, they are given the autonomy to hire their PCAs and to supervise that work and to choose who they want to work for them. And that's something that the legislature intended to happen and not to insert the Commonwealth into that employer-employee relationship. Lastly, I think Ms. Jackson raised it briefly in her appellate brief. She asked that sovereign immunity be waived here. I suggest that, even if we get beyond the clear language here of the statute and the regulations, there's been no waiver of sovereign immunity under Chapter 151.
As I read the brief, I think Ms. Jackson is asking that we abrogate the doctrine of sovereign immunity.
That's correct. That is what she asked. I'll note that both below, during which she was represented by counsel and in her appellate brief, she hasn't identified any provision for that waiver here, and there is no clear waiver, nor should there one be found by necessarily implication. And again, I think just returning to the plain text of the statute over PCAs and the regulations, I think the answer here is clear that EOHHS is just not the employer of Ms. Jackson, and is not the employer of PCAs.
Maybe I'm not sure if you can answer this, but maybe it should go to Mr. Heineman. But Ms. Jackson is putting the time in. She feels compelled to stay with the I'll call him the patient, because he cannot help himself, and she feels, for various reasons, moral reasons, ethical reasons, whatever, that she can't walk away after 3 hours. Now, there is a process that was pointed out that determination of payment for 3 hours could be appealed, and not on the record before us is it indicated whether that has or has not happened. There's been discussion of a surrogate. And it seems like Ms. Jackson, and I don't mean to put words in her mouth, but feels as though that's something that comes from the patient's side. Like, in other words, it would be a family member and he doesn't have any. Or is there a surrogate program that this patient can get a surrogate that's there for him that's not a volunteer, like a family member, if you know?
I don't know the exact answer to that, Your Honor. My understanding is that when members are first enrolled into this or join this PCA program, they are evaluated in the first instance as to whether or not they themselves are competent to undertake all the responsibilities of being a member, or if they require a surrogate. And I know that there are surrogates who are essentially required for many members who participate, including children and those who require legal guardians. And so as to whether or not
that's the case at inception. What are we to do in circumstances as possibly obtained here, where the condition of a patient, of a consumer changes, deteriorates, and they are in a position where they require greater care, but not in a position to prosecute a request for an increase in their reimbursement levels?
Yes, Chief Justice, my understanding is that there is that essentially an annual reevaluation process. So at that time, if it's determined that someone requires a surrogate to continue in this program, that could be determined in between.
So is it possible to initiate that review in between that annual review if the consumer, him or herself, is unable to do so?
I don't know.
So who can do that?
I don't know the answer exactly, Chief Justice. My understanding, though, is that there are opportunities to request adjustments to the coverage, and so perhaps Attorney Heineman knows more, but I imagine there is an opportunity as well to request an evaluation as to whether or not a member would need a surrogate to continue.
Do we know how long this member's been in the? Does somebody have the streaming live? Because I hear an echo, which makes me feel like there's feedback from a device. Do we know when the last time this member was reviewed?
I don't believe. I apologize, Your Honor. I don't believe that's been. I don't believe that's anywhere in the record or alleged in the complaint. And just to conclude, I think for these three reasons, the court should affirm the dismissal of these claims against EOHHS because simply as a matter of law, there's no employer-employee relationship between us and Ms. Jackson. And unless the panel has any other questions, I'm happy to rest on the brief.
Seeing none. Oh, I'm sorry. Do you have another question? No. Seeing no further questions, that concludes the argument of this case. The case is submitted. Thank you. It's live.
All right, we are live and recording.
Our next case this morning is case number 2020 P188, Emerald Home Care, Inc. versus the Department of Unemployment Assistance. You may begin.
Good morning, Your Honors. May it please the court. Arthur Cormier for Emerald Home Care. By way of disclosure, I'm both the counsel for Emerald Home Care and the owner of the company. This is an appeal of the first decision in American history upholding a free speech restriction on a tax. Under this tax regime, you must agree that you will not speak about what you are being taxed on. In this case, you were being
Is that true? I'm going to interrupt you right there.
Sure.
Because that seems to be the premise, but I'm not sure that that's the fact. Here, the only information that you're not provided by way of the due process argument is the name of the actual employees.
Right.
Initially, and they ask you to sign the confidentiality agreement before you're able to get that name. But they tell you how many employees, they tell you how the figure is being calculated. They tell you what the appellate process is if you disagree. The only information, it seems to me, that you don't get is the name of the actual employee without signing the confidentiality agreement.
That's
correct. How does that impinge on your speech? You're free to criticize the program.
Okay, so first of all, on the due process side, all that other stuff is just window dressing. There's absolutely no way to figure out whether you're properly assessed unless you have the names of the individuals they are claiming are your employees on Mass Health. So right there, All that other stuff really doesn't matter. It's just window dressing. If I do not have the names of the employees they claim are mine on Mass Health, I have absolutely no idea whether I've been properly taxed. And now let's say I get those names, and for whatever reason, I don't like why I'm being taxed. I have the right to call up my elected representatives and complain about that and be as specific as I want to be. Right? There's absolutely nothing in free speech jurisprudence that allows the government to try to protect someone from what might be embarrassing speech, right? And personally, that wouldn't be my intent. My intent would be to raise an issue. I think frequently that individuals are stuck and they're not able to work as much as they would like to because otherwise they lose their benefits. So I mean, in my particular case,
Mr. Cormier?
Yes, sir.
So the limitation is that you can't identify the person to say your elected official, but you could complain about the process, the way it's determined, the way the taxation itself or the supplementation you can complain about. You just can't identify the individual person by name who is the subject of that tax.
Right, but that could be completely relevant. And one of the most effective ways of communicating is using specific examples.
Well, how is the name relevant to the issue?
I'm sorry.
How is it that the name is relevant to the issue?
Because somebody may be on Mass Health that shouldn't be on Mass Health. Somebody could be deliberately not working enough so that they...
If that is true, it is true based on the facts and circumstances surrounding their status and their involvement, not
you can use the name.
Based on their name.
I'm sorry, say that again?
I said, if that is so, it is because of the facts and circumstances relating to their legal status, their position, their activities, or what have you. It has, their name does not bear on the concerns that you've identified.
Yeah, I guess I fundamentally don't agree with that. If
we don't have to agree.
What's that?
I said we don't have to agree.
No, I know we don't, sir.
Okay.
So one person is being asked to pay a tax on another person because of the status of that other person.
Correct.
And they're being told that they have no right to question the status of the other person, to speak about it in any identifiable way. And
that's not correct. You have the ability to get the information you need in order to identify the particulars of the individuals that are involved, and you may challenge the treatment of that individual based on the characteristics that led to that determination. But you have not yet identified what it is about the name that affects, as opposed to the characteristics associated with that name that bears on the eligibility.
So if I called up my elected representative and I said, look, I have 10 employees that I'm paying taxes on and I don't like it, I think you should look into their cases, right? Here they are. I can't say that. I'm not allowed to say that. I mean, I should be allowed to broadcast that as much.
What you can say is that I have 10 employees. I don't think I should be paying taxes on them. And here's why. Employee number 1, here are the facts. Employee number 2, here are the facts. Employee number 3, here are the facts. And with that, armed with that information and that detail, your representative could inquire of the department of why it is that on those facts, without the name, but with those facts, the determination was made as it was. Again, I mean, you're identifying something that you suggest would enable your representative to engage in advocacy on your behalf in a somewhat different way, but not in a manner that identifies how the name bears on their eligibility for benefits.
Right, and that's exactly what the government's not allowed to do, right? So it's crystal clear in the law that you can't have, like, I don't have to beat around the bush in making my statement. Like, there's a First Circuit case that I cited and the lower court ignored, which specifically states that any regulation that limits the words that you can say is a content-based restriction, and that's subject to strict scrutiny. So if somehow this could survive strict scrutiny, which I don't think it ever possibly could, then I lose. But it is a content-based restriction, and I just don't see how it possibly survives strict scrutiny. Like it's fundamentally a tax that limits how you can speak about it. It says you have to pay a tax on this other individual, and you can't say anything about them in an identifiable manner. Well, and there's just no reason to have a tax like that.
So I'm going to interrupt you. Two questions. One is, with respect to your ability to challenge the tax, which is where I think you started. I thought that the second exception to the confidentiality agreement says that you had to maintain the confidentiality of the information pursuant to the state Medicaid statute, except as necessary to review and or appeal. So to the extent that you needed to use that name, as you argue here today, somehow as the foundation of your appeal, number two seems to provide for that. And
it doesn't allow me, sorry, it doesn't allow me to speak to my elected representatives, my family, my friends. Like, well, that's all I can do is talk to the DUA about it. I mean, that's a huge restriction.
But it allows you to effectuate the appeal. You started with, how can I challenge it? I think that's where we began. If I don't know who they are, did I miss that?
Yeah, but I get to not even if they're correct. I get to complain that I don't like paying a tax on them. Like even if it's
and nobody's telling you can't complain.
You're limiting how I can talk about it, which again is a content-based restriction. And
which case do you rely on for that? Which case you said the court ignored your case? Which case?
Hold on, I have it there in my notes.
AIDS Action Committee.
It's AIDS Action Committee of Mass versus Mass Bay Transportation, First Circuit case, 1994.
Yeah, and in
AIDS, it's frankly just common usage. I have to change the content of what I'm saying. I can't say I don't like paying a tax on John Doe. I have to change the content. I have to say I don't like paying a tax on a certain employee. I mean, it's clear that the content has to be changed.
So you say that AIDS Action Committee stands for the proposition that there's no limitations on speech. Is that what I hear you say?
No, that's too broad, right? What I'm saying is it stands for the proposition that if you're controlling what words I can use, then that's a content-based restriction, and it's subject to strict scrutiny. That's what it stands for. And again, I think just as a matter of common sense, that's got to be true, right? If you're actually saying words I can't say, you're affecting the content of the message.
I thought that AIDS concluded with, in the end, the MBTA. We're talking about advertisement that was going on inside the cars of subway trains or trains, I'll say.
Yeah.
In the end, the MBTA may well be entitled to exclude from the interiors of its cars speech containing a certain level of sexual innuendo and double entendre. So even that case says there may be instances where they can limit the speech. Isn't that what the case says?
Well, so again, like if you can show me that this restriction survives strict scrutiny, maybe something with sexual innuendo would, but if you can show me that this would survive strict scrutiny, then I lose. But I can't see how it possibly can, because the compelling government interest here is raising revenue. And there's so many ways that the government can raise revenue without touching free speech at all, right? It could raise the tolls on the Mass Pike. It could increase sales tax. I mean, it could do anything, but it doesn't need to limit speech. So there's just no way this survives strict scrutiny. And again, it's content-based. You have to apply strict scrutiny. I don't see any way around that. So all right. So now, all right. So I'm going to try to figure out what. Sorry, how much time do I have here?
3 minutes.
3 minutes.
Sorry, how many?
About 3 minutes. 3 minutes and 5 seconds. Yeah.
Okay. So I'll just cherry pick one thing that the court just comes up with a reasonableness standard out of thin air, right? There is no reasonableness standard to substantive due process restrictions or substantive free speech restrictions. There just isn't. I mean, Hitler, Mao, and Stalin could get along thinking that their restrictions were reasonable. Like the First Amendment is a declaration that free speech restrictions, at least substantive ones, are probably per se unreasonable. So there just is no reasonableness standard here, and I don't know how he derived it. And he also relies on these right of access cases, which are essentially cases where you would look to these cases if you were wondering whether the media could go look at a top secret military base. It makes absolutely no sense to apply that line of cases in the procedural due process context. There is procedural due process case law, and that's what should be applied. And it was just completely ignored. So again, as a matter of procedural due process, I'm entitled to information sufficient to have a meaningful hearing, and that wasn't provided. It's not conditional. It's just not conditional. That's the core of the right, and the right to condition implies the right to deny, and they don't have the right not to give me the information. And then what they're doing is they're punishing me for not agreeing to limit my speech, and I'm essentially losing my due process rights, right? So if I don't agree or I don't agree to limit my speech, I'm being punished for what I might say. All right. So I think, and just that looking at this from 1,000 feet, this is the first ever, as far as I can tell, free speech restriction on a tax. Taxing is one of the most coercive functions of government. There's absolutely no good reason to have a free speech restriction on a tax. Thank you, Your Honors.
Thank you. For the department?
Yes, Your Honor. Andrew Hale on behalf of the Department of Unemployment Insurance. I would like to start with just getting back to Justice Desmond's question from the very beginning of my brother's argument. There is no meaningful way that this privacy restriction infringes Emerald's speech. Emerald, just to go ahead and borrow an analogy that my brother used in the lower court, Emerald is free to complain about this fee to whoever he wants. He can walk into any bar, for example, and complain to anybody. He can show anybody that he wants the EMAX supplement determination, which of course explains the tax or the fee and the basis for it. The only thing that he cannot do is say the names and the social security numbers of the individual employees for which the fee was assessed. He could even, going back to what we were just discussing, walk into his legislator's office and simply use a pseudonym and say, I've got these 10 employees, we'll call them Joe and Mary Smith. They are erroneously on Mass Health. I think there's some fraud going on, and so on and so forth. He could do all of those things without just simply saying the names and the social security numbers of his particular employees. And of course, there are good reasons for the Commonwealth to maintain that kind of medical privacy, both in this program and elsewhere.
Let me see if I can frame the argument as best I understand it. He's arguing in the first instance, the information he's looking to talk about with unfettered freedom is information that he doesn't currently have, but is in the control of the department. And so, as I understand it, his threshold contention is that to deny him access to that information while imposing a tax based on the information would deny him due process. And his second argument is that conditioning his access to that information on a limitation on his use of it outside of his procedural rights that were at the core of his due process argument is an impermissible infringement on his First Amendment rights.
That's correct, Your Honor. So if it makes sense, I'm happy to take that kind of due process question first. As we know from our cases, due process requires notice and an opportunity to be heard. And Emerald was afforded both of those things in this case. So again, the supplement determination, just on its face, says how much you're being assessed, for how many employees, provides the rationale for that, and then it provides a link to the list of employees for which somebody is being assessed. It also provides, and you can see this in the record appendix on pages 16 and 17, a request for hearing documentation document, which includes the whole procedure by which somebody could request a hearing, which of course Emerald did. Based on the case law, that is more than enough to satisfy the notice requirements under the procedural due process analysis.
So you're suggesting that he has no constitutional entitlement to get this additional detail in the first instance?
No, Your Honor, I'm not suggesting that in particular. I'm suggesting that the notice that he received was constitutionally adequate. And I would point the courts to the Strasnick and the LaPointe cases.
Well, but I mean, I'm not sure I understand the difference between those two, because if you're saying it was constitutionally adequate, that also is saying that he is not constitutionally at least entitled to anything more than what he received in the notice.
Your Honor, I'm not sure that as a matter, I'm not sure that he's constitutionally entitled. But respectfully, I think he has the initial EMAC supplement determination. He also has the list of names. So those two things together, I think my brother even agrees, if you look at his brief on page 20, that those two things together are perfectly sufficient for notice. His real issue is being asked to sign the privacy certification.
No, well, that's the thing about which he makes the most strenuous objection in this appeal, as I read his brief. But I guess I'm trying to see the sequencing and the framing of the issue in order to ask you the following question. If his entitlement to this information starts with a due process right to be able to make use of it in order to challenge his assessment, are his First Amendment rights around that information defined or bounded by that procedural purpose?
So I guess, can I ask you, I mean, I guess is the question, to the extent that his First Amendment rights are infringed somehow through this procedure, the answer would be no. And the First Amendment is not even implicated, let alone violated in this case. And I would point
about the First Amendment rights. The First Amendment rights, as I understand it, the claims are infringed, are the rights that are limited by agreeing to the confidentiality by the certification. Mm-hmm. And if that right is derivative of the due process procedural right to mount a challenge, then are the permissible limitations on his First Amendment right basically satisfied, so long as he is able to proceed in the manner that the due process requirements required?
Yes, Your Honor. I think if I understand correctly, yeah,
If you don't, it's not your fault. I've been more articulate at various times in my life, I promise.
I think he has, of course, the key is he has the right to these names, and he has the right to use them in whatever way he wants to the extent that they are necessary to his appeal, which guards his due process rights. If he wants to say that this supplement was erroneously assessed, these particular employees were not actually on Mass Health, a DUA made a miscalculation of the amount, he can do all of those things within the context of his appeal. The issue is when we get to sharing the names and the Social Security numbers of these employees publicly, which he does not have a right to do to the extent that he received that information from the government within the context of this assessment of the fee. If I could just address that First Amendment question a little bit further. So we've identified in our brief that there is no implication of the First Amendment in a situation where you have government-held information and the government is providing that information to an individual or to a member of the public, the government can place restrictions on that, or even choose not to give it out at all under the line of access cases which we cite.
Well, that's why I started with the question of what is the foundation of his right, his claimed right to obtain the information in the first place, and if he has a constitutional basis underpinning his claim of entitlement to get the information in the first place, it seems to me that the source, the foundation of that constitutional right should frame and bound the permissible limitation First Amendment use of the information if it's given out.
That's correct, Your Honor. We're not saying he has no right in this particular situation where he's being assessed a fee on the basis of his employees triggering liability under the supplement. We're saying that in the context of that appeal, he would have a right to those names, and he in fact does have those names, and he can pursue his appeal in order to challenge the accuracy of the supplement or in any other way. But it's when my brother then says, I need these names to go sit down with my legislator or create a petition or write an op-ed, there's no right to do those things outside the context of the appeal, nor is there any meaningful speech infringement, as we've already discussed. He could do all the things that he wants to do, simply stopping short of saying, I'm not going to share my social security number or the name of my employee who's on Matt's Health. So, and I would just draw an analogy, Your Honor. We're thinking about this, for example, in the context of a criminal proceeding where the government is proceeding against a defendant. You have the full coercive weight of the government. The defendant, in order to have a constitutional right to his own defense, he needs, for example, the mental health records of a victim who's testifying against him. He doesn't have a constitutional First Amendment right to get those mental health records, and certainly doesn't have a constitutional right to publicize them outside the context of that proceeding. Same, for example, with the government use of confidential informants, which, again, there's informer's privilege, and there's a whole sort of framework that the court has drawn up around when a CI, for example, their identity could be disclosed. But again, there's no First Amendment right to publish that outside of the context of the proceeding. And that is a much more coercive environment here, being asked to pay a fee on the basis of health insurance. So, and again, the potential sort of consequences of my brother's argument are widespread when you think about, for example, whistleblowers, when you think about civil discovery, protective orders in cases involving civil discovery. And of course, this goes to the Seattle Times case, which we cite in our brief, where you had a newspaper, again, with an arguably much heightened First Amendment interest, getting information through the civil discovery process and challenging the protective order, which was placed on that, and saying, look, we are a newspaper, this is newsworthy information, we want a right to publicize this. And the Supreme Court said, no, there is no First Amendment right to publicize information that you received as part of this court process. Yes, Your Honor.
Do you have anything in particular that you want to say about the AIDS Action Committee case?
If I could, just that we're talking about apples to oranges. So in a case like that, you have, the MBTA, which has all manner of advertisements, all manner of speech happening within its advertisements on its train cars, but then it picks out this one particular idea and says, we are not going to allow this idea to be expressed on our train cars. We're just in a different situation here. And it's not as if DUA is giving out the names of all these people, but saying, only you, employer, you cannot use these names in this particular circumstance. Or, for example, which would obviously be unconstitutional, you can use these names, but not if you want to use them in the context of suing us. So that would present a very different case. But that's not the case that we have here. And I would also point the court to the Sorrell versus IMS Health case, the 2011 Supreme Court case, which explicitly said narrow and well-justified privacy restrictions that deal, for example, with the medical privacy issue, and it explicitly cites HIPAA, are perfectly consistent with the First Amendment. And so, again, that was dicta in that case, but I do think that puts us in a different category. As a final matter, I would just urge the court, there is this, Emerald purports to bring us a claim under the Supremacy Clause of the US Constitution. As we said in our brief, the Armstrong case says, quote, the supremacy clause certainly does not create a cause of action. And Emerald actually agrees with that idea on its brief on page 35. And so I would ask the court to uphold the dismissal of that claim as well. I would also just argue, I would just remind the court, this is a temporary program. It has since expired. I'm not aware of any other particular challenges to this law. The law itself strikes that careful balance between an employer's due process rights to understand and to challenge a fee that is being asked to pay, and the medical privacy of individuals who are on government subsidized health insurance. The lower court found that this didn't even implicate, let alone violate the First Amendment, and I would ask the court to hold the same.
Thank you. Thank you. Thank you both. The case is submitted.
Thank you, Your Honor.
I will call the case once we are live.
All right, we are live and recording.
Okay, that brings us to the last case on our list today, case number 2019-P1777, Oak Ridge Realty Trust IX versus the Lincoln Zoning Board of Appeals and others. You may begin.
I go first, Your Honor.
Yes, you do. You're the appellant.
Okay. Good morning. Good afternoon, sirs. This case, as you've read the briefs and you're familiar with the procedural background and the facts of the case, what, in my opinion, this case boils down to is two essential issues. Is one, that the building, the construction of the treehouse within the setbacks created a new non-conforming structure on the property and was not a mere alteration of a pre-existing non-conforming structure that would have been allowed under a special permit. However, the new structure built right on the property line created an additional conformity, making the entire property even less conforming than it was before. And that creation would necessitate the issuance of a variance rather than a special permit, despite what the bylaw says. The second basic issue of the case is that as the Lincoln bylaw is written, while it may seem a little bit odd, it's very specific in its allowance of an exception to the setback guidance. The bylaw clearly states that in section 13.4, which is what the building inspector had required that the headlands get a permit under, it says that the setback can be waived if these two sections are met. Section 6.2F and section 20.2C. 20.2C being the general guidelines for the issuing of a special permit, and 6.2F relating specifically to a radio tower. Now, this may seem like an odd way to write out the bylaw. However, there was a case from 1984 where a resident of Lincoln was issued a special permit for a radio tower utilizing this particular section. So we know that this guideline has been in place in the town of Lincoln for at least 30 to 40 years. And so it was obviously very, very purposely written to allow only an exception to the setback requirements.
Is the cross-reference to the cell tower section of the bylaw a reference for substance or procedure?
It seems to be a reference for substance, and that it.
Why do you say that? As I read the accessory structure, it says that anyone may proceed on a special permit for an accessory structure by getting a special permit in accordance with 6F, but that doesn't mean that that it imports all of the substance that is specifically applicable to cell towers only.
Well, that's where it seems a little bit odd, is that it's specifically written for that one exception.
Odd is one way. What we often use in construing statutory provisions is the word absurd.
Well, I would disagree that it's absurd, because if it's certainly within a town's authority to say that there are no exceptions except for a particular list of items.
No, but an easy way to reconcile that, they've done that by identifying the accessory structures that may be authorized by means of a special permit, and they've identified the procedures that govern how one goes about getting a special permit.
Right. What they've done is they've outlined accessory structures and then saying you need to get a special permit for these.
If they were going to limit the accessory structures that were eligible, then why wouldn't that section say only in the case of cell towers would it be available by special permit?
I don't think that they're limiting the number of accessories, the type of accessory structures that can be permitted as long as they meet that setback requirement. I think what the bylaw is saying is that only this particular structure can be exempt from the setback requirements.
So for that purpose, and going back down through the list of rules of construction that we apply, we also often take into account the interpretation applied by the local officials who are charged with its administration, right?
Yes, and I believe
and here that would be the building inspector and the ZBA.
Right, and the building inspector said that you need a special permit, and the ZBA said that if you had come to us before you started construction, we most likely would have told you not to put it there. So that's a recognition.
No, but they authorized it, and they authorized it using the application of these provisions of the bylaw, right?
But our argument is that they misapplied the bylaw themselves by not reading it as it is written.
Right. Okay. I want to go back for a moment to your argument about the variance requirement and the fact that we are adding a new. Please remind me, if you would, of the nature of the pre-existing nonconformity.
I believe that the existing nonconformity is that the lot does not meet the setback requirements to begin with, so that the housing structure is too forward on the front of the lot, so it's within the buffer zone to begin with.
On the front yard, but
Yes.
There's nothing on the side yard.
That I'm not sure of off the top of my head.
So when you say you're introducing a new nonconformity or exacerbating the existing nonconformity, first of all, exacerbating the existing nonconformity, as I recall, is also authorized by getting what's called a Section 6 finding. Is that right?
I'm not sure.
I think that's the way it works. But if you introduce an entirely new nonconformity, but doesn't that beg the question about whether the accessory structure is permissible upon the issuance of the special permit? The conversation that we were having a little while ago.
Right. I think that it would be that the creation of the accessory structure is permissible under a special permit as long as it meets the requirements of the setback.
So really, if we get to the point where in order to get to the variance issue, you need to prevail on the bylaw interpretation that this was not permissible by means of a special permit as an accessory structure.
I don't think that you necessarily have to. I think that you can make the argument alone that it should have been a variance, regardless of what the.
You can make that argument. It's up to us to decide whether it goes anywhere. But the question of whether if an accessory structure within the side yard is authorized by special permit, how do you get to the point that a variance is required? What's that argument then?
The argument is that by placing it within the setback, you've created a nonconformity.
But it's not nonconforming if it complies with the bylaw that specifically authorizes it upon the issuance of a special permit, and you get the special permit.
Right, but that has to meet the 20-foot setback requirement in order to be granted the special permit.
Unless the bylaw exempts accessory structures from the side yard. So we're back to the first conversation.
Right.
Okay. So
that only the tower is the one that is allowed to be an exemption.
Right. So that to just distill this down, if the exemption of the side yard requirement applies only to cell towers, then this was not permissible by special permit and would have required a variance. If the bylaw allows accessory structures within the side yard by special permit, then the zoning board's decision should be affirmed. Is that right? Do I have that right?
The zoning board's decision should only be affirmed if you're going to read the bylaw of section 13.4 as that 6.2F and 20C don't have to be met together. If you're going to,
I understand the argument that underpins the final conclusion. I'm just trying to get it. If when you take all of the bylaw provisions together, if those bylaw provisions do not authorize an accessory structure within the required side yard by special permit, then a variance is needed. If the bylaw provisions all taken together do authorize an accessory structure within the side yard by special permit, then special permit issue, the issuance of a special permit is permissible, and the special permit in this case was within the board's authority, and the homeowner is good to go. Is that correct?
I can't disagree with that, no, but with the contention being that the only exemption allowed is for cell towers or radio towers.
Right. So we're back to the question whether the cross reference in 6F to cell towers means that the only accessory structures that are authorized within the side yard are cell towers.
Right, within that setback, yes.
Well, it's in a case that involves at its core the permissibility of a treehouse. It's nice to know that we've been able to narrow the questions that we need to answer to that narrow question.
Yes.
The closer we look, the smaller it all gets.
It is, exactly. It's a small point, but I think that it's important because if a board is allowed to simply disregard its own bylaws, then what's the purpose of having the bylaws to begin with?
I understand that, which reminds me of a different question. I take it that there was no question engaged in the trial court concerning your client's standing?
No, there wasn't.
Mm-hmm.
Because of there being direct abutters.
Are you a direct abutter?
Yes.
I didn't think you were a direct abutter.
Yes, their property lines line up right behind each other on the rear end of the appellee's property.
Well, but being a direct abutter does not confer automatic standing. You know that. Right.
That's been my understanding as to what the generally accepted rule has been, though. That the exemption that we've seen is in a case that did not involve direct abutters in terms of a grievance.
Well, there's a lot more law on standing than that. But the question wasn't engaged in the trial court, so we don't need to spend much time on it here.
Okay.
Is there a photograph of the treehouse in the record? One of the things you say is that it could become an eyesore and you have some other problems with it. Do we see it in the record? I can't find it.
They're in black and white. They're hard to view, but they're
yes,
out of the record.
The treehouse is in the picture?
Yes.
I've looked at the pictures. I can't make it out.
You're right. You can't. It's hard to view.
Yeah, the black and white photos due to the filing requirements, we had to submit in black and white, and it is a bit difficult to see. We could certainly make color photos available if you wanted.
That's all right. I'm sure it's visible. My ears are going too.
All right. Is there anything else you want to tell us?
No, I think that pretty much summarized my argument in that what we've gone over.
All right. Thank you very much. We'll hear from the appellee.
All right. Hi, everyone. Representing myself, so forgive me if I don't follow the process as directly as I should. So do you, just to answer the previous question, there in volume 3 of the appendix, there are some color photos. If they didn't come through color for you, those are the best ones that we had submitted. Do you have that in your record? I think that just be a helpful reference.
They didn't come through as colored.
Oh, they didn't? Like page 28 in volume 3 of the appendix doesn't come through as colored?
No.
It doesn't?
No.
Can
those are the ones that I've been looking at, but no.
Oh, really? Okay. Can I share my screen? Is that appropriate?
We don't ordinarily use chalks in this, but yeah, let's go ahead. This is a color picture. Unless Attorney Angley has an objection to providing a color version of the exhibit that was provided below.
You're on mute, sir.
So I was just trying to find. You're referring to the photos that you submitted, Mr. Headland?
They're in your appendix, actually, volume 3 of your appendix.
Yes, but this is page 25, 26.
28 actually.
Right. It's 25 through 30 almost, but they're all black and white.
Yeah. Okay. It doesn't just maybe this help. It doesn't look like I'm able to share my screen. It looks like you have it turned off in the settings.
Yeah, and I'm not sure that I have the. I know that I'm not the host, so we'll get by. But thank you.
Okay.
Yeah, just trying to with the black and whites.
Yeah, sure. So there's 2 comments I would make about to help with the initial question. So it's approximately 150 feet away from his house. He's the 3rd closest abutting neighbor. There is actually not direct line of sight from treehouse to his property. It's intersected by the other neighbor's property down a fairly significant hill. The other piece of information I think is important is one of the claims along the way, and there have been a lot of claims made along the way, is that this is somehow an invasion of his privacy, which I completely, on paper, I totally respect, and I would never want anyone to feel that way. However, there's a publicly accessible conservation trail between the treehouse and his house, which anyone can walk through, and somewhere between, I don't know, 3 or 5 or 10 people a day walk through there. So the suggestion that the treehouse is any more an invasion of his privacy than the passing of the hikers on that trail is rather hard to believe. There's in that same document, if it's helpful, this will be the last point I make. Is page 22 clear?
Black and white, but it's clear.
Okay, so there I just mapped out, and these are what I submitted into the Superior Court trial that he submitted in his appendix. So this just maps out and further dimensionalizes the property and how they fit together. So there's my house, Headland. There's the tree house. That red line. Oh, you can't see the red, but the line between the two is a conservation trail, publicly accessible on all the town trail maps, etc. And then there's the plaintiff's house. So the property line that we have built closest to is not his. That is our right abutting neighbor, Donna, who has written a letter of support for the treehouse. And then the property actually intersects between the neighbor that you can see to the right. His property goes sort of at an angle between our two. So he's, as I said, the 3rd closest abutting neighbor. Enough on the context. I'll just be really brief. I feel like we're already at the heart of the matter. We and the entire town read section 6.2 and section 20.2 as those are different options, as opposed to 20.2 being a subset of 6.2. Given the way they're described, it seems impossible to believe that it was ever intended to only refer to radio towers in those. We feel like they were correct in issuing us the special permit. Along the way, we follow the process at every stage. The other thing that I would introduce here that I think is important is we started building the treehouse without a permit. We didn't know that we needed one. I tried the website, the town website a bunch of times, but there's no reference to it. They call it an accessory, an enclosed structure or something, not using that word. So I wasn't able to find it. So in the town hearing, the structure was 80% built. So we brought with us to the town hearing for the special permit every one of these pictures showing what it looked like, where it was, what it looked like from all the angles, and all the other neighbors' support for it. So this wasn't a conceptual plan that they were agreeing to give us the special permit. This was the real situated, mostly built structure that we have today. I don't think I need to go through the rest of the argument. The only thing I would further emphasize is the amount of claims that have brought up that things like that the treehouse is attracting trespassers, and that parties are aggregating on the congregating in the treehouse. Again, these are all things that on paper are very serious claims that if they were real, I would love to see the proof so that we can address them. If it's attracting treehouse, we should all call the police and understand who that is so that never happens again.
I appreciate your need to address some of those, Mr. Hedlund, because as the property owner, it probably is very important. But our focus is really on the issue of the distinction between the variance or the special permit.
Of course.
And Mr. Angley has addressed that, and I think in some way, shape, or form has indicated that if the permit was appropriate under that section, that a variance was not needed. So the question is whether the permit was appropriate under that section.
Certainly. Okay.
So that's where we're going to focus.
Understood.
I have one other question. I mean, I noticed in volume 4 toward the very end at page 127 to 129, there are some color pictures. I wonder if you can tell us what those are, what those depict.
Sure. Let me just get volume 4 up. Hang on a sec. Tell me the pages again.
127, they're at the very end. 127, 128, 129. 3 pictures. All in color.
Oh, all right.
Yeah, so those are the photos that he took actually. So I think the 127 is so that's the view from the trail to the treehouse.
So the gray structure with the window.
That's the treehouse.
Sort of flat sloping roof. In 128 showing an open doorway. That is the treehouse.
Yeah, right. Correct.
So it's a treehouse
actually in a tree.
It's right.
Sorry, it is in a tree. You just can't tell from this picture. The way the land slopes so sharply down, you basically can't see it. It's on a stilt and it's connected to the tree.
Look at the next picture, 128. The same thing?
I can't. That's a strange looking photo with a peculiar telephoto lens.
That is the tree house that we are dealing with.
Yeah, correct.
And though it's not evident from the angles that we have on those exhibits, you're telling us that it is in fact a tree house that is in a tree, not a tree house that's on the ground.
Yeah, correct. It has it's attached to a tree and it has 2 stilts to support the outside walls.
Okay.
I think
there's a house that's depicted in on page 128 in behind it in the background of it.
Yeah.
Is that
so that is I think a bit of a misleading picture. That is the treehouse, my house behind it, which is you can see it's a little bit yellow. That's since been painted. And then on the other side is the across the street neighbor's house. So this is the perspective.
So there's multiple. Okay, so there's 3 structures. Okay.
Yeah. Yeah.
Right, I'm fine.
I think the clearest is on 127, which is not a telephoto lens photo. It's basically from the conservation trail down the hill to the treehouse. So again, this trail intersects my property and his. So his is about 75 feet further away from this.
Well, that answers both my questions and satisfies my curiosity. I don't know if there's anything else you need to tell us, but and I don't want me to speak for my colleagues.
Nothing else on my end. Let me know if there are questions.
I'm all set.
Seeing none, that will conclude the argument in this case. The case is submitted, and it also concludes our session.